The topic that we're going to talk about today is how to better protect wages and working conditions for farm workers. The plight of farm workers during the COVID-19 pandemic era has been the subject of many headlines the past year, and usually not for good reasons. I'm going to switch these off. I'm
sorry for the technical glitches. I'm going to switch microphones. What I wanted to say is that farm workers have been infected by COVID-19 and have lost their lives at disproportionately high rates, which has also put their families at risk. I think we all know that they've been deemed quote unquote essential workers and aren't able to work from home. And this, of course, is on top of the already dangerous work that they do. Even before the pandemic, Labor Department data showed that farm workers experience above average rates of workplace injuries. They've also been doing work without being adequately paid for it. By any objective measure, farm workers are some of the lowest paid workers in the entire labor market. In 2019, on average, they earned less per hour than workers with less than a high school diploma, who are the lowest earners by education level. And they only earned 60% of what comparable workers outside of agriculture earned. So I think there's no question that farm workers deserve better, and there's really no better time than now to figure out how to deliver for them. A small silver lining of the attention that's been brought to the current situation as a result of how stark it is that some awareness has been raised about the conditions that farm workers face on the job. And so while we're appreciating everything that farm workers do, and while many people are referring to them as heroes, we wondered, as researchers, can we dig a little deeper? Can we get a better sense of what farm workers are facing on the job and how employers are treating them? Can we get some insight into which workers are the most vulnerable? Which employers break laws more frequently? Are there any patterns? For example, are there crops or commodities or regions or counties where violations are more likely to occur? And so that was the main goal that my co-authors and I set out on when we started looking at the available data from the Labor Department's Wage and Hour Division, which culminated in the EPI report we published. Which will be online, and you can go to epi.org to see it, and you can follow us on Twitter at economic policy. So with this report, we figured that if we can get some deeper insights into these questions, and I think that we did, then more importantly, how can we use that information to inform what government officials are doing who are actually in charge of policing the labor market, so that they can better enforce the law and hold employers accountable, and so that farm workers get every penny that they've worked so hard to earn. This is particularly important now that a new administration is in office and putting in place a team and developing new priorities to protect workers. So while I think our report is useful to really get an idea of what's happening on the ground, I mean, we have to look to others like our panelists, and that's ultimately what we're here to do and what we're going to discuss today. And we have a very distinguished panel with expertise on this, each of whom have a deep knowledge of the issue, but who come at it from different approaches, which I think will allow us to take a deep and holistic look at how to improve labor standards for farm workers. So I'll quickly introduce them now. One of our panelists is David Weil, who is a former administrator, in other words, he was the boss of the Wage and Hour Division at the US Department of Labor during the Obama administration. David is currently Dean and Professor at the Heller School at Brandeis University. We also have Valdemar Velasquez, who is the president and founder of one of the main farm worker unions in the United States, the Farm Labor Organizing Committee, also known by their acronym FLOC. We also have Janice Fine, who is a professor at Rutgers University, as well as the research and strategy director for the Center for Innovation in Worker Organization. Janice, along with David, is unquestionably one of the smartest people looking at labor standards enforcement issues and has extensive knowledge about labor markets and enforcement strategies. I'll also introduce you to the co-authors of the report we published, and they will spend a few minutes presenting the report to you. First is Philip Martin. He's Professor Emeritus of Agricultural and Resource Economics at the University of California, Davis. He's worked on farm labor and immigration for, I think, close to 4 decades now, and he's written scores of books on the topic. And last but not least is Zach Rutledge, who is an applied economist and currently a postdoctoral research scholar at Arizona State University, specializing in immigration, farm labor, and agricultural economics. So in terms of the run of show, I am now just going to speak for another 4 or 5 minutes to offer a little more background and context about the issue in the report. And then Phil and Zach will present for no more than 20 minutes altogether, and then we'll get right into the panel discussion. And we promise to leave ample time for Q&A with the audience, probably close to half an hour. So please be thinking of your questions and putting them in the Q&A box, and we will be sure to ask as many of them as time allows. So I want to start just by saying a quick word about the farm worker population, because I think it's good to know how many workers we're talking about and some of the major characteristics. Unfortunately, no one knows the exact number of workers employed on US farms during the year, although there are multiple estimates. The quarterly census of employment and wages, or QCEW, shows that average annual employment of farm workers who are on farms that report to state unemployment insurance agencies was 1.3 million in 2019, but it's estimated that there are an additional 400,000 workers who aren't counted, which would mean average annual employment of 1.7 million. An issue with the QCEW, however, is that it reports average employment, which underestimates the number of unique farm workers. Then you have another source of data, which is the Census of Agriculture, which asks farmers how many workers they employ directly. In 2017, farmers reported hiring 2.4 million farm workers. However, that data source doesn't really report workers who are brought to farms by non-farm employers like labor contractors, and it double counts workers employed by 2 farms or more. So that means that 2.4 million is not a count of unique farm workers either. At least it's not an accurate count. There are other estimates, but I think you get the point. So then when it comes to demographics of farm workers, one of the main sources is the National Agricultural Worker Survey, or the NAWS. The NAWS is a great data source. It reports the characteristics of farm workers. It tells us where they're from, their immigration status, things like whether or not they have healthcare coverage, but it doesn't tell us the number of workers. NAWS also doesn't cover an entire 10% of the farm workforce, which is the H-2A program, and that's something that many of the panelists will be talking about later. But I will just say, as a means of introduction into the H-2A program, is that it is a temporary or non-immigrant work visa program, which allows migrant workers to work in the US on farms for less than a year. Employers are supposed to first prove to the Labor Department that they tried and failed to hire US workers before hiring H-2A workers, although there have been reported issues with how that works. Last year, there were over 213,000 H-2A workers employed. That's the most ever. And I won't go into it now in depth, but I just want to note that EPI, along with numerous migrant worker advocates, news exposés, government audits, et cetera, have been pointing out the severe flaws in temporary work visa programs for years, including H-2A, in part because the visas are owned and controlled by employers, meaning that if workers complain and get fired, they become deportable. And workers, often before they even get here, pay illegal recruitment fees. They also have no path to permanent residence. And there's a slew of other issues, which you'll hear about a bit more. So just to emphasize a point about immigration status and farm workers, since I touched on it with H-2A, as I just noted, 10% of farm workers are H-2A workers with a precarious legal status. Then the NAWS shows that roughly half of all crop farm workers outside of H-2A are unauthorized immigrants. Then you have about 1/4 who are US-born citizens, with the remainder being immigrants who are either naturalized or naturalized citizens, or who are permanent immigrants with green cards. I realize I just threw a lot of shares and numbers out there, but the main takeaway is that only roughly 40% of farm workers are US citizens and legal immigrants with full rights and agency in the labor market. And that means that the majority of farm workers are vulnerable to violations because of their rights, and unable in practice to seek redress through the legal system because of their immigration status. The final point to mention with respect to that is that the immigration status of farm workers and the fear of retaliation and deportation that they have because of it, and even perhaps the perception that government officials won't take action or will fail to obtain meaningful remedies for them, can really contribute to farm workers not reporting violations when they happen. As a result, the violations that are actually reported and detected, and the fines actually assessed on employers, are almost certainly just the tip of the iceberg when it comes to workplace violations suffered by farm workers. So just try to keep that in mind as we talk about that today. Now, with that being said, I'll just conclude with a couple words about the data that you're going to hear about and the relevant agency that those data come from. The data that will be presented and discussed come from enforcement actions taken by the US Department of Labor's Wage and Hour Division, or WHD, which is the federal agency that protects the rights of all workers, including farm workers, in terms of wage and hour laws, and it enforces the US's main wage and hour law, which is the Fair Labor Standards Act. WHD also enforces 2 laws, and they're implementing regulations specific to agricultural employment. One is the Migrant and Seasonal Worker Protection Act, or MISPA. That's the major federal law that protects farm workers. And the other is the statute that establishes the H-2A program. What WHD does not enforce are health and safety laws. That's obviously been a major issue during the pandemic, but those laws are enforced by another agency in DOL, the Occupational Safety and Health Administration, or OSHA. So the data that Phil and Zach will present cover the investigations and enforcement actions of WHD only. And we looked at aggregate data covering 2000 to 2019, and then more detailed data of enforcement actions on farms going from 2005 to 2019. So I think that's enough background. I'll stop there. And I know the panelists will provide a lot more info about what WHD does and doesn't do, and you can ask questions about it later. But for now, I will pass on to Phil Martin, who will present a quick summary of our report.
Okay. Whoa. Am I sharing my screen as I'm supposed to be? There we go. Sorry. I'm Phil Martin. I want to thank you all for being here. I want to thank Daniel for introducing and Zach for doing the data analysis and the commentators for commenting. But the most important point to make is this one up front. This is the number of WHD enforcement actions in agriculture over the last 20 years. And as you can see, we've gone from roughly 200 agricultural investigations a month to about 100 agricultural investigations a month. The general idea is that the United States has somewhere between 105,000 farm employers and 500,000 farm employers. As Daniel was mentioning, if you look at the number of employers, farm employers registered in unemployment insurance, you get about 105,000. If you look at the number of farms who say they had expenses for hired labor, you get about 500,000. But regardless of which you use, the probability of being investigated in any year is a little under 1%. What happens when there is an investigation? Well, in 70% of the investigations, you find violations. So it's important to emphasize that about 30% of the investigations find no violations of federal labor law. And about another 30% find 5 or more violations. So it's almost this U shape of what you have. And if you look at the right-hand side of the U, the so-called bad apples that commit a high share of violations, you find regardless of the commodity or the area, the 5% of the agricultural employers with the most violations account for between half and 3/4 of all violations. And that's another way of saying the same thing is if there were some way to get those bad apples to comply or put them out of business, you could see the total number of violations in apples or in oranges or in strawberries drop by over half. Question is, what do you do about it? Well, the obvious answer is there should be more enforcement, but that alone, of course, may not change behavior. Could you do higher penalties on repeat violators or set some threshold of violations? One idea people have is require repeat offenders to submit payroll data and then use algorithms to check. That's borrowing an idea from food safety, where you measure the quality of the water and the residue and the pesticides and things and get a continuous motion picture of what's going on in farms so that you can detect things that are out of the norms. Another thing we'll see is that the H-2A program in the last several years has replaced MISPA, that ag-specific law, as the main source of back wages and civil money penalties. So that program is growing, and there may have to be more done to target potential violations there. So the picture on what we find in agriculture is that the amount of back wages found owed and the civil money penalties levied peaked in 2013, and it's been dropping somewhat since, roughly 5 million in back wages, 6 million in civil money penalties last year. And as I just mentioned, H-2A violations now account for more back wages and civil money penalties than violations of the MISPA law. I already mentioned also the U-shaped nature of the results of investigations. Roughly 30% find no violations, and a little over 30% find 5 or more violations. And then obviously the other third is in between. If we look at farm labor contractors, so farm labor contractors are non-farm employers who bring workers to farms. They account for about 1/7 of average agricultural employment in the US, and they account for about 1/4 of all the violations detected in agriculture. And as you can see with labor contractors, there's that same basic U shape. A quarter have no violations, but now 35% have 5 or more violations. 3 states account for 40% of all the investigations in agriculture. Florida has about a 1/6, Texas has about an 1/8, and California has about a 1/9. So Florida, Texas, and California account for about 40% of all the investigations. In Florida, you can clearly see that the total number of violations found in agriculture is driven by labor contractors. And the share of total violations found attributed or found with labor contractors has been rising over the last several years. If we look at California, we can look at 2 different maps. The first says where were violations found by county over the last 15 years. And then the second map on the right says, what's the share of agricultural employment in that county in 2019? And what you see, of course, is that in the so-called Central Valley, where with Fresno and Tulare and Kern counties, there's a high share of violations, which makes sense. That's where there's a high share of farm workers. But what does stand out are 2 counties that you normally would not think of as having a lot of violations, but yet they do. One is Lassen County, which is up in the mountains. And why does that show up in red? It's because there's a lot of H-2A workers employed in strawberry nurseries. The second is Imperial County, which is right down on the border with Mexico. Once again, they're not big shares of ag employment, but they're big shares of violations because of H-2As. And that's a theme that's going to come through over and over again, that the H-2A program in recent years has been the major source, even though, as Daniel emphasized, it's only 10% of average employment in crop farms. It's the largest single source of back wages and civil money penalties. We can look at the same thing for just farm labor contractors. What share of violations found among farm labor contractors were in particular counties? And as you can see, once again, the San Joaquin Valley, where most of the farm workers are, half of all farm workers in California are in the San Joaquin Valley. Those are in dark red. That's where many and most of the violations are, exactly what you'd expect. But then if you put farm labor violations as a share of farm labor employment, farm labor contractor violations as a share of farm labor contractor employment, you'll notice that the ratio is biggest in Los Angeles County and San Bernardino County. So you can look at these things in a lot of different ways: the total number of violations found, or the ratio of the share of violations to the share of employment. I've been mentioning labor contractors because the share of workers brought to farms by non-farm employers, of whom most are labor contractors, has been rising. That's the black line for the US, and the top orange line is those workers hired directly by crop farmers. But if you notice in California, the bottom 2 lines, since 2009, more workers have been brought to crop farms by non-farm employers than were hired directly. And the gap is widening. So when you see a group of people working in a field in California, chances are they're not employed directly by that farm operator. They're brought to that farm by a non-farm employer. So we have a picture of violations, shares of violations, but now I want to focus on bad apples. And this is the employers with the most violations and what share they have of all violations found. So if you just take the top 10 employers by number of violations, they're a fraction of all investigations, but they're 14% of all the violations that are found. The same thing is true with labor contractors. Once again, you take the 10 US labor contractors with the most violations, and you find that they account for 1/6 of all the violations that were found among labor contractors, and also a high share of the back wages, 10% of all the back wages that are owed. If we just look at California labor contractors, it's the same story. The 10 with the most violations account for 28% of all the violations and about 22% of the back wages owed. This story of a small share of employers accounting for a big share of all the violations and back wages comes through regardless of how we look at the data. So if we take all crop farms in the United States and we say, among all those crop farms that were investigated, who had the most violations? Well, the 5% of the farms with the most violations accounted for 70% of all the violations found. You're going to see a few more diagrams like this that make this point over and over again. In a cumulative distribution, the 5% of the entities that had the most violations account for 50 to 75% of all the violations found. So it's true of labor contractors. The 5% with the most, 2/3 of all the violations found among labor contractors. If we look at grape farms, the 5% of the grape farms with the most violations, 55% of all the violations found in grapes. Same thing is true in strawberries. The 5% with the most account for 3/4 of all the violations found in strawberries. And the same thing is true in H-2A investigations. The 5% of the farms that had the most violations accounted for over half of all the violations that were detected in the H-2A program. We're going to take this one step further and say, how can we compare the share of violations in a North American industry standard classification NAICS code with the share of employment in that particular NAICS code? And so what we're really doing is saying, among all the violations that are found and assigned to a particular commodity code, what share is in each, and then what share of employment was in that commodity in 2019. And the story that we get is that whenever there are a lot of H-2A workers, there are a lot of violations. So who stands out on top? Sheep and goats. Who would have ever thought? But sheep and goats are a sector that employs very few workers and a relatively high share of H-2A guest workers. And so the share of violations found in sheep and goats is about 8 times their share of employment. Forest nursery, same story. A relatively small share of employment, a large share of violation. Vegetables, labor contracts. Where is it lowest? So where do we have a lower share of violations than the share of employment? It's in year-round jobs. In cattle and dairy, they're not eligible by and large to employ H-2A workers. You can look at the same data in a picture, and if we had the same share of violations as share of employment, these would all be at 1, but we don't. Instead, we have sheep and goats on the top, and we have cattle and dairy at the bottom. So to sum it all up, big question to looking at these data is, how do you really deal with the bad apples who commit a high share of the violations that are found? Is there some way to require the submission of data in a way that allows automatic sort of monitoring? I mean, looking at the food safety model, instead of a snapshot audit, how do you create a motion picture so you can see what's going on? I think it's important to emphasize that the H-2A program has become the major source of back wages and civil money penalties, not MISPA. That was the case for most years, but in the last 5 years, it's changed. Is there some way to better cooperate between wage and hour and the Office of Foreign Labor Certification to look more carefully at job orders to detect any kind of patterns? There are employers whose business model depends on violating labor laws. We know this is true in agriculture and other industries. Is there some way to identify them? Is there any way to try to bring them into compliance, force them into compliance? What we didn't do here is look at back wages and CMPs that are actually paid. Is there any way to do more of that? And then finally, as Daniel was mentioning, can we integrate these violation data with other data? So this is a big area. We've looked at some data. In 2 weeks, if you're interested, there's going to be a presentation. Daniel will be there as well, talking about an issue that Daniel was alluding to. Many people hope that the farm labor issue goes away as countries get richer. As countries get richer, fewer people are employed in agriculture. But the share of wage or hired workers employed in agriculture goes up. 95% of people were employed in agriculture in the 1790 census. Today, it's 1.5%. But within agriculture, hired workers do a higher share of work than they obviously did back in 1790. And those hired workers, as Daniel was mentioning, are more vulnerable because they're the local workers who can't get out, can't find a non-farm job, and they're joined by migrants from abroad. So if you're interested, in 2 weeks, that will happen. So I am now going to stop sharing and turn it over to Zach.
Great, thank you, Phil. Let me share my screen here. Okay. Can you see my screen? Great. Okay, so hi everyone. Thank you for joining us. My name is Zach Rutledge. I am a postdoctoral research scholar at Arizona State University, and I did the data analysis on this project. And so I'm going to share a select set of the findings from our report. So I'm going to start off by showing an overview of the US and where violations are taking place in the agricultural sector. You can see the dark red states are the states that have the most violations. And I've highlighted the top 5 violating states with a dark outline. The reason why I'm showing this graph is because I wanted to highlight that California is the state that has the most violations. And that makes sense because California is also the largest agricultural employer in the US too. So I'm going to hone in on California a little bit to start out here. So if you look within California, this is a map similar to the one that Phil showed earlier, where his was the share, and now I'm just showing the actual number of violations in each county. But worth noting here is I've highlighted the biggest ag counties in this dark black outline. And you can see here, red means that there are a higher number of ag violations. You can see that most of the agricultural violations in California are occurring in the big ag states, and that's as we would expect. But if you focus on the probability that an investigation actually finds a violation, it's actually, if you look anywhere throughout the whole state, there's a high probability. So the yellow and red are the counties that have the higher probabilities, with red being the worst. And you can see, conditional on an investigation being conducted, the probability of finding an investigation is very high throughout the whole state. So what we ended up doing is running an analysis of NAICS codes within California. So what I did is I calculated the probability of finding a violation among different agricultural employer groups. So we looked at vegetable farmers, fruit farmers, nursery crop farmers, and some of the others. And what we noticed is that the farm labor contractors, which Phil mentioned earlier, are agricultural employers that recruit workers and bring them to farms. They're actually the employers in California that are the worst violators. In fact, investigations in California, investigations among farm labor contractors find violations about 85% of the time. Interestingly, though, if you look at the other codes here, the other employer groups, the probability of finding a violation among these other groups is also very high. So we thought these findings were particularly interesting, and particularly the farm labor contractors, who are kind of their own group here, appear to be the worst violators. So part of the analysis we did, we wanted to try to see if the civil money penalties that are assessed to agricultural employers who are found in violation of a labor standard, if the amount of civil monetary penalties affected the probability that those employers engaged in a repeat violation or were found in violation in a subsequent investigation. So I'm not going to get into the details of the statistical modeling here, but basically what we did is I ran some regression analysis, some regression models where I was looking at the statistical association between civil monetary penalties and the probability of engaging in a repeat violation. And basically, we were unable to uncover any meaningful statistical relationship between these two variables. So basically, what we would have liked to have seen is a negative correlation, meaning that if an employer is caught in violation and is assessed a lot of CMPs, then they would be less likely to engage in a repeat violation. And we didn't find any evidence of that. So the results from this part of our analysis, we interpret as being suggestive that civil money penalties do not appear to deter repeat offenders, excuse me. So to sum up what we're finding, basically we find that agricultural employers are often found in violation of labor standards throughout the US. In California, these violations are mainly found in the big ag counties, which is what we would expect. Farm labor contractors are the worst violators, but all agricultural employers seem to have a high probability of being found in violation, which gets back to the anecdote that Phil was talking about with respect to the restaurant workers. And then we find suggestive evidence that indicates that civil money penalties do not appear to deter repeat offenders. Now, so I'm going to, I guess that's basically the end of my presentation, but I wanted to provide a couple of data suggestions for improving the data moving forward. As I was working through the data, I noticed that there were a number of things that I think could have been improved. And so I just wanted to quickly go over those for the WHD folks that are with us today. One of the things that I noticed was that the data does not include a variable that identifies the county. First, it only includes the state, the city, and the zip code. And so that makes it difficult to match the database to other databases or aggregate data at the county level, because zip codes in a lot of cases will cross county boundaries. So you can't really assign them to counties. And then there was an issue I came across with employer names being entered into the database. Sometimes the same employer had a different, it was typed into the database slightly differently. And particularly I noticed differences in the abbreviation for incorporated, INC, and that made it really difficult to track the same employers throughout the whole database. So my suggestion is to implement some kind of uniform standard, particularly for entering employer names in the database. And then, as Phil mentioned, H-2As are becoming increasingly prevalent throughout the, H-2A workers are becoming increasingly prevalent throughout the US. So it would be nice if we could identify the employers as H-2A employers or not. Basically, just a simple question that would ask them, do you employ H-2A workers, would be really helpful. As of now, we can only determine if they're an H-2A employer if they were found in violation of an H-2A labor standard. But if we were able to have data on whether they were employing H-2A workers, we could potentially track them better over time. And then as Phil mentioned, it would be nice to have some kind of information about the case disposition and the wages and CMPs that were actually paid by the employers. That would be really useful going forward. And so that's all I have. Thank you so much. And if you have any questions, you can email me or reach out to me, and I'd be happy to help answer any questions. Thank you.
Great, thank you so much, Phil and Zach. And so with that, I'd like to get the discussion started. And I think I'd like to start with David. David, you ran the wage and hour division, and you are generally known as having been an innovator during your time there. So you're particularly well positioned to kick off the discussion. Sort of what do you think broadly is the significance of the report's findings? Do you think they're significant? And in general terms, do you think that what was shown kind of tracks with how things actually play out on the ground? And maybe you can tell us a little bit more about how those actions actually do play out on the ground.
Sure. So first of all, thank you, Daniel, for inviting me to be on this great panel and to comment on this really important and terrific report. And I certainly commend Daniel, Philip, and Zach for what they've done in amassing a huge amount of data and doing a lot of very useful and important analysis of it. I want to start by just being very clear. As you said, Daniel, I am the former head of Wage and Hour Division. I am not currently in Wage and Hour, so what I'm saying is a reflection of my own views and reflections, both as a long-time academic studying the issues of enforcement in many industries and including agriculture, and as having the honor of serving in the Wage and Hour Division for 3 years during the Obama administration. And I'm also thrilled to be on the panel with my good friend and fellow academic enthusiast in labor standards, all things labor standards, Janice Fine, and my good friend Valdemar Velasquez, who I also had the good fortune of working with in the Dunlop Commission, which I'm sure Valdemar is going to talk more about, many very pertinent issues about how H-2A plays out in North Carolina in particular, where there's some real innovations. So my overall reaction to the report is I think it's very consistent with what I know to be, or what I certainly have observed to be the case in agriculture in terms of both the challenges facing the Wage and Hour Division in addressing the profound problems that exist under FLSA, MISPA, and the H-2A programs, and more importantly, the profoundly bad conditions that thousands and thousands of farm workers under all those programs face every day with respect to wages. There's a little less comment there's more in the paper, less in just some of the summary today, but equally the problems around housing, around transportation, and around exposure to all kinds of risks, including the pandemic risk. And so I think the report does a great job in highlighting, number one, the fundamental resource problem facing Wage and Hour, that there are simply not enough investigators present to do the work in an important industry like agriculture, where the problems are so prevalent, as well as many other industries where low-wage workers face profound problems. But it could not be more striking in the case of agriculture. And the numbers themselves just reveal the problem. During the Obama administration, at the peak of the Obama administration, through the hard work of the president and a lot of other people, and with the ongoing opposition of Congress at the time, we were able to have a peak of 1,100 investigators at the highest point in the Obama administration. Right now, there are less than 780 investigators in the field. And that speaks to just a profound resource problem that is highlighted in the report. And if you look at the appropriations, I mean, all you have to do is download the latest president's budget that shows the budgetary appropriations of the Wage and Hour Division. Since 2010, they have basically hovered around $227 million and have gone up and down by trivial amounts around that since 2010. So an 11-year flatline budget, despite certainly efforts throughout the Obama administration to raise that. I don't think there were any such efforts from the Trump administration. But that's number one, and I think the report highlights it too nicely. Secondly, the report really highlights the prevalence of the problem. The fact that, in the vast majority of cases, whether those are H-2A or cases under FLSA and MISPA, you find violations. And that speaks to the level of the problems. You also find lots and lots of civil monetary penalties, which means there were violations significant enough to invoke those penalties. And that suggests both the need for what we're talking about, and that is more investigations, but also how deeply rooted they are and how pervasive they are. And I want to get back to that in a moment. Another point highlighted in the report that I think is that people cannot understate, and that is the fear of reprisals and retaliation that pervade this industry. You cannot have effective investigations if workers are frightened to speak to investigators. One of the things the Wage and Hour Division did in a very focused way during the Obama years was trying to build trust among farm workers that they could both reach out to the government to report violations, and then when the government was present, to talk to those investigators and tell their stories and tell what's going on and in a whole range of things. That was difficult, very, very difficult during the Obama administration, as I'm sure it was before then. One can only imagine after the last 4 years of immigration policy, the denigration of immigrant workers, everything we have seen over this last period of time by the Trump administration, how that level of fear and reprisal is all the higher. And I think the report highlights how that is a fundamental issue. Any strategy has to begin with a recognition of that issue, has to begin with building trust with the workforce and building other institutions that can help build that trust, or institutions like FLOC, institutions like other worker advocacy organizations, consulates, other kinds of institutions that can be a bridge. There's a huge amount of work to be done there. The point on the prevalence of bad apples, I could not agree with more as well. The disproportionate share of violations that are focused on a subset of players. I think the problem is there are a significant number of bad apples out there. So figuring out, I hope in our discussion we can talk further about how do you use different techniques to identify them. It's a profoundly important problem in a world of constrained resources. What I want to just finish with, and I want to give my colleagues a chance to talk, is it's not, however, I mean, actually, if you take the pieces of this report and put it together, it speaks to the fact that, yes, we need more resources, but that's not the entire answer. That you will never have enough resources to do one-by-one investigations to take on this problem. The report alludes to something that we called strategic enforcement, which is a very different attitude about how you deploy those resources, how you use a whole range of tools, including but not limited to investigations and CMPs, not just to recover back wages and not just to assess CMPs, but really to reduce the prevalence and severity of wage theft, to redress inadequate housing, to reduce safety and health risks from transportation and access to water and hygienic facilities and exposures from things like the pandemic, and to assure just basic treatment, that respectful treatment for some of the hardest working, if not the hardest working people in our society. That's the challenge. And I think, again, in our conversation, I hope we talk more about, it's not just investigations. It's not even just targeting and investigations. It's a broader, more comprehensive approach of trying to change the factors that lead to such pervasive noncompliance.
To that end, David, before I move on to Baltimore, I was wondering if maybe in just 1 minute you could tell us something that we alluded to in the report, which was something that you are known for developing, which is called strategic enforcement. And we couldn't find out that much information about it. We sort of referenced it and cited it, but we would love to know more, just briefly, of kind of what what that really was and what kind of an
Right.
impact it could have, and was it abandoned after you left?
As anyone knows me knows, say something briefly is not my strong suit, but I will do my best. And I think a lot of what we did, there were basic principles of it that are institutionalized in wage and hour division. I can't speak to the environment in which the dedicated career people in wage and hour found themselves in the last 4 years, in an environment that was hostile to, I think, a lot of the work they're doing. That is an unenviable position. I continue to have the deepest respect for the men and women who do the enforcement under very adverse political conditions. And I think you can't understate that problem in this period of time. So I don't want to comment on what was or wasn't in place during the last 4 years, because I frankly don't know exactly what was being used or what wasn't. What we talked about strategic enforcement was saying there are a number of tools that need and should be used by wage and hour to really make sure that you are affecting the conditions that lead to non-compliance. Because very often a farm labor contractor, and there are all kinds of farm labor contractors, and again, Valdemar can speak to sort of the evolution of that in under different situations. But what one sometimes finds with FLCs is they're at the bottom of this chain. They are being paid a price to provide laborers to a grower, who is being paid a price to provide crops to a wholesaler, who is being paid a price to provide crops to a retailer. And every level of that chain implies someone getting a margin, which means there's less and less to pay the worker at the bottom of that chain. Strategic enforcement was trying to figure out what were those chains, what were the dynamics of the chains, and how ultimately can you bring the proper pressure to everyone up and down that chain so that you align what people are supposed to be doing because of what the law states with what they're being compensated with and how the economics of the chain work. So for instance, again, I want to go into it because it's a big issue. I hope we could talk some about it. The hot goods provision, which is part of the Fair Labor Standards Act, was something we used in agriculture during the Obama administration. We used it very carefully. We used it in close consultation with the solicitor's office because of the high standards that requires. But it is a way of making people further up in the chain responsible for the violations that occur further down. And that's an important tool of strategic enforcement, but that's not where it ends. You use that tool in order to do things like something called enhanced compliance agreements, which is once you get back wages, you reach an agreement with the parties, including parties further up the chain, to behave differently in the future, to do things like monitoring, to do things like much more active education of people in the chain and of workers of their rights, to create a different kind of system that will sustain compliance in the future. Education is an important component, outreach, not only to workers, worker advocates, but also to employer associations. It is a comprehensive view of using all the tools available to an agency to sustain and improve compliance. That's what strategic enforcement is in a nutshell.
All right, thank you. So Baltimore, I'd love to move to you to kind of ask you, what in the report, if anything, jumped out to you in terms of the major findings, and do they mostly correspond of your perspective of how things look out on the ground? You're the best person on this panel to kind of tell us what this looks like in the real world. And can you give us your thoughts on the farm labor contractor model and your work on trying to improve things where we found most of the violations are occurring? Got you muted still.
There you go. Thank you, Daniel. Thank you for the invitation to be on this panel with David and Janice and Zach and Philip. That was a great report. It really confirms my sense and feeling on the ground about what's happening. I think that the issue, the farm labor contractors that you cited, is really an old problem. It's not a new problem. These big farm labor contractors who are now bringing in H-2A workers, they're the same type of contractors that we used to call crew leaders, labor contractors that prior to bringing in H-2A workers, they work with trafficked workers, undocumented people. And before that, there were crew leaders that brought families like mine from South Texas up to the Midwestern part of the United States to harvest crops. So that's been part of the agricultural model for a long time. It's just morphed into this new model with the rise of the H-2A program. And I'm sorry to say that I think the regulatory improvements, I think, are good because the standards are needed for us to fight and organize around, but they're not going to solve all the problems because in this H-2A program, many of the abuses start in Mexico on the recruiting end, where we don't have regulatory authority. And so they bring that problem across the border into the United States. But I think David, in his last statement there, in terms of defining what happens in the supply chain, what are the forces that move decision making on the ground to go to the farm labor contractor, independent farm labor contractor model? It's a very seductive opportunity for either a large corporate farm on the basis of either greed or sustainability, because contrary to what some people might think, that these farm labor contractors, the farmers think that they're distancing themselves from liability and put all the problems of the workers on these independent farm labor contractors, who are notorious for cheating workers, for wage theft and so on. And we've sued a couple of them. We filed complaints with the Department of Labor. And I think all your recommendations on improving the number of inspectors, the number of enforcement mechanisms, more finances to support the Department of Labor, all those are good, but it doesn't solve all the problems. For instance, we sued a big farm labor contractor a couple of years ago. We're into the settlement area now, and we're helping the Department of Labor find the workers because they can't keep track of them in order to deliver the bond money that the farm labor contract put up. And it's almost impossible to find that farm labor contractors if he's got any other resources or property and things like that, because they move around so much. So there's an enforcement challenge there. And I think supporting the Department of Labor to help them get more help in that area would be good, but it doesn't solve all the problem. I think the problems are going to have to be solved in a number of other manners. And one of the things is we have to redefine the questions I had for Philip and Zach is that where these violations you're documenting, do you have any documentation of the size of those farms? Because I suspect that they're rather large farms. And these farm labor contractors is the number of workers that they have. I'm sure it's not 20 or 30 workers. They're probably in the hundreds of workers that they bring as contractors. What we're seeing in the middle part of the United States, from Michigan, Ohio, Kentucky, Tennessee, North Carolina, Virginia, Tennessee, is that the farming is a bit different than in California. And when we have a debate in Washington about the regulatory issues in the Department of Labor governing the H-2A labor program, it impacts the Midwest growers much different than the West Coast that are largely larger farms, corporate farms. And in the Midwest, we have the small family farms that may hire anywhere from 5 to 30 workers, H-2A workers or otherwise. So they're small family farms, and the regulatory standards, as David pointed out, the larger farms are going to more easily consume or take the regulatory changes as far as wages, and then a lot easier than the small family farms. And they're further marginalizing the farms on the regulations. And we're letting the manufacturers and retailers and the buyers of the crops, and I'm talking about growers who are suppliers to large retail stores, food chains, manufacturers, whose pricing of their crops marginalizes them, and therefore they in turn hire independent farm labor contractors to save some money in terms of their sustainability. I think the solutions can have to be pointed in a couple of new directions. One, there has to be some formula to tie farm worker wages on the bottom of these supply chains to commodity prices, particularly to those farms that are suppliers to these large corporations. And secondly, there has to be some kind of what I learned from the National Farmers Union is that there has to be some kind of management of the supply, which means that we have to do something about imports because the large corporate farms can outsource their growing. We see a lot of American big corporate farms opening operations in Mexico in more and more degree. You'll see that our trade balance with Mexico over the last 10 years is completely the reverse now. We import more food in these vegetables and fruit from Mexico that we export. That's completely turned around in the last decade. And so I think this is going to have to be tied into our trade policy to protect farming in America, which becomes a security issue because if we depend on all our food supply to come from external sources, we have no independence on that as a country. And I think it's going to be important for us to take a look at how we preserve small family farms and therefore preserve the jobs of the workers that we represent. So in a nutshell, that's kind of like a serious challenge that we have. When David was the wage and hour guy, I remember us talking about the role of these independent farm labor contractors at that time. We were trying to make the case, and we still push this whole thing about joint employment. And I think if they were made to, if the law would be changed so that these farm labor contractors would have to be joint employers on the farms that they place workers on, that would make the vigilance of their compliance more important to the farmer than it is now, or completely ban them from using H-2A workers, giving them those visas, and push the farmers to employ the workers directly. I think that would help the compliance, but that will not save the family farmer from the marginalization that he suffers from the imposition of low prices from fruit, vegetables, tobacco, or whatever they're selling to manufacturers and retailers.
All right, thank you so much, Baltimore. Appreciate that. I'll move on to Janice. Kind of the same question of sort of what jumped out at you in the report. What did you think was significant, and what do you think should be done about some of the problems that we're talking about here? Are there other strategies that can be applicable from other models, maybe that include workers or organizations, or anything else that you've looked at that would tell us how to tackle this problem that we haven't thought about? Muted.
Sorry about that. First of all, I just want to say again, Daniel, how excellent I think the report is, and how comprehensive it is, and how powerful it is, and that I hope that we'll have opportunity to see this acted on, and also that we'll have equally comprehensive studies of other sectors. I don't want to repeat what's already been said. I'll just say that David Weil has taught me more than any human being on the planet Earth about how to think about enforcement, and Baltimore Velasquez has taught me more about thinking about agriculture and about guest workers and about organizing in ag. And so it's a real pleasure and an honor to be in their presence. And so I guess I just want to say a couple of things just straight off the bat. One is that the most fundamental reason why we're in this pickle, pardon the expression, Baltimore, is an asymmetry of power, right? And that we have to address the asymmetry of power. Like, this just isn't going to change, right? So that we understand that the penalties aren't high enough, that the penalties aren't deterring. But the other is that if people like Baldemar Velasquez, Cesar Chavez, Dolores Huerta, there's been amazing people, brilliant people organizing in ag who have struggled to really build mass-based organizations. It should tell us that something's got to give around, support for organizing and the recognition on the part of the Wage and Hour Division and the Department of Labor and President Biden that this is not a sector that's going to get cleaned up without a lot of blood and guts on the floor and a lot of organizing. And that, the proposals that are being made around a path to citizenship and doing something about the terrible violations in the H-2A program, about undocumented workers and their fear of speaking up, the need for massive overhaul of retaliation provisions. I have a lot of specifics about that I'm happy to share. All these things are necessary. And I have to say that what's so wonderful about the report is it sort of, it tells us that 5% of farms were responsible for 70% of the violations, right? So, we have some sense of who to name and shame, right? Who to go after, who to target. David has taught us so much about the utility of strategic enforcement. So I think that it's really, really important to think about how do we clean up this sector. I'm so tired of this attitude that the poor will just always be with us. So, farm work is always going to be bad work, as opposed to, okay, so fundamentally what must be done? And number one on my list is we've got to empower worker organizations and workers themselves to have major agency in their own organizations and their own fights. And then, and I can say more about that later, but the other thing is, I think, the discussion about the farm labor contractors, I'm going to be dating myself, but it reminds me of those old Henny Youngman jokes, when he goes to the doctor and he says, doctor, it hurts when I go like this. And so the doctor says, so don't go like this, right? Like, we know the farm labor contract system is terrible, right? And we know that if we have direct workers directly on farmers' payrolls, it makes a huge difference. So, I think that, there are a number of lessons and a number of things that we can learn from, for example, the best of what Baldemar has done in terms of organizing guest workers, and the best of what's been done by the Fair Food Program and the Fair Food Standards Council, and now the work that they're doing in Vermont, but the work that really started with the Coalition of Immokalee Workers. And that's the importance of market consequences. Another thing I would say is that I think what happened to David when he was Wage and Hour Director was that, when he started to really use that hot goods authority and to really go after major bad players in ag, he got attacked, right? They really went after the Department of Labor, and we had a brilliant solicitor and all that, but we need to have a Department of Labor that's going to stand by and not get spooked when it gets attacked in court, and when the growers throw everything they have at them, and when the right goes after them in Congress. There has to be a kind of a moral recognition on the part of the Department of Labor that we can't survive without farm workers, and that means that when the smartest strategies are deployed by some of the smartest people in our country around enforcement, they've got to stand up and back these strategies. And if we lose one court case, then, we've got to do, 10 more. And so, and I'll just say, David always says, and I agree with him, that we're never going to have enough investigators, which is why, in part, I believe so strongly that we have to really focus on organizing, and that the federal government needs to say in no uncertain terms that it supports organizing, and that an organized labor market is a much more compliant labor market. On the other hand, we have 143 million workers in the United States. According to the ILO, we should have one investigator for every 10,000 workers. That means that we should have about 14,300 investigators. Now, I know we can all chuckle at that idea, but in agriculture, in these states like Florida, California, Texas, where we know there's terrible things happening to farm workers and have been going on for a long time, and no state enforcement, right? Jeb Bush eliminated the Department of Labor. We have a responsibility to go into those states with a very, very heavy federal footprint. And in my view, we should be talking about thousands more investigators. And I agree with David, we should deploy them incredibly smartly, right? And we should think about where they should go. But that one thing we know from the Fair Food Program is that having local resources on the ground monitoring what's happening in the farms is essential. And so as much as I agree with a lot of the recommendations that Phil and you and Zach talked about, algorithms and monitoring payrolls and all that kind of stuff, the bottom line is that these are feudal relationships that have a long and horrible racialized oppressive history. And that we also have to have people on the ground. We have to have monitoring on the ground. So those are just some quick reactions.
Great, thank you. So now, being cognizant of time, I wanted to see if we can do just a quick lightning round. I want to hear from all three of you, just in a minute or two, the top line recommendations that you would have for the new incoming DOL and Biden administration. I realize you may have already alluded to some of them already, but if you could just kind of reiterate, encapsulate in a minute or two what each of you think about that. Maybe starting with David, and I will ask David another angle of that question to you is what to do about this political pushback that you're ultimately going to get, the DOL, the wage and hours ultimately going to get back from legislators, from policymakers once you actually start enforcing the law, and employers get mad and they call their legislators and they say, hey, why are you bothering me?
Well, I'll start with that one. I mean, that's basic any strategy. I mean, one of the reasons we did as much as we did is, I would say fundamentally, Tom Perez had my back and supported what I was doing, and I think Tom Perez had Barack Obama's back. I mean, that is fundamental. I agree with Janice. We need to take that up a notch. I think that we learned we knew and we faced two of the longest hours in my life was being called in front of a House Agriculture Subcommittee about our hot goods authority, where I actually created a bipartisan moment. I was flayed by both Democrats and Republicans equally on that committee. And you can watch it. It took me 4 years before I could even watch it on YouTube. And we knew we were going to get that reaction, and it is tough. And so you do need to, basically hunker down and be ready for the fact that enforcement occurs in a political context. And if we believe in improving conditions for farm workers, we got to be ready to take the fight on both sides of the aisle. I mean, it was very interesting. I kept waiting for the cavalry to come over the hill in that committee meeting, and it never did on either side. That is something that I think can be addressed through politics. I would love to have thousands more investigators. I would say if I look in the context against political realities, I've estimated you need about $105 million budget increase over current budgets to get to a reasonable state, to get to a state of the number of investigators and the support and wage and hour that you would need to really have a reasonable baseline program to deal with industries like agriculture. And that's to up the number of investigators by at least something close to 1,000 more investigators. But you also have to build in information technology and infrastructure to do the kinds of things that Phil was talking about, to use data better, to coordinate better, you need to increase things like the solicitor's office because you need that hand in glove. So I think there's an appropriation story that does get back to a recommendation of your report and being more specific about that. What exactly would that look like? That's something like a 46% increase in the budget. And that's to me a baseline kind of thing one would need. And then and beyond that, I think it really does require not only this kind of approach to enforcement within the agency, but it requires the kind of all the different parts that ultimately improve compliance, improve conditions for farm workers on the ground. And that means the work of organizations like Flock and the leadership of people like Valdemar, the work of worker centers that Janice has studied and advised for years, immigrant rights groups, and things like consulates. It is thinking about and also working together with different groups who bring different assets and different ways to address this problem, and ultimately is how you create sustainable improvements in conditions.
Thanks. Baltimore, in a minute or two. Any top line recommendations to the new
Yes.
DOL?
I have 3 recommendations. I like things in threes: Father, Son, and Holy Ghost. They always come good together. Number 1 is have the Department of Labor really push to eliminate these FLCs from H-2A visas, or make them be joint employers with the farms that they bring workers to. Secondly, I would say that there has to be some kind of initiative to tie the prices of commodities that farmers supply to major manufacturers and corporations to some sustainable model that manages the market supply that they sell their commodities to, because you have to keep that farm sustainable to be able to be in compliance, the money that it costs to be in compliance for wages and conditions for farm workers that come to work on their farms. And this is important to us. And number 3, going along with that, would be freedom of association. Give farm workers the right to organize and organize their own unions or collective bargaining. I think we tied these 3 things in that we pioneered in our first agreements with the Campbell Soup companies in the 80s, because we not only we did a strike of 2,000 tomato workers, but the strike, even though they were on farms, these tomato farms that were contracted to the Campbell Soup Company and Heinz USA and some of these big tomato companies, our target was the companies to negotiate with us. Now, this was a very provocative move, because everybody said there's nothing in the law that that says that manufacturers have to negotiate with a group of workers of their suppliers. That was kind of like a crazy idea. But our hot goods strategy was the boycott, and we boycotted that company until we made them negotiate a supply chain agreement that included their farmers, their suppliers, and the farm workers, and got the money from the company to increase the price of tomatoes to facilitate doubling the wages of the workers, giving us a health insurance policy so that we don't depend on charity on these fairly funded migrant programs. And we had some degree of self-determination. And I think that unless farm workers have the right to freedom of association, we're going to continue to be recipients of these good gestures of programs that want to help us. And I think it's time that America modernizes labor relations in agriculture and finally give workers a right to organize, freedom of association, collective bargaining. We want our rights. We want to be able to be self-determined and not be a charity case to the American public.
Great, thank you. Janice?
I agree with everything that's been said, everything that Valdemar said, everything that David said. I would just add a few other ideas. One is, I think we have to really ask ourselves, how can farm workers and farm worker organizations play more of a role in wage and hour enforcement, and really think through what that could look like. I think we have to strengthen retaliation protections to more effectively hold businesses that retaliate against employees who speak up liable. And I think that there needs to be a rebuttable presumption that an adverse action taken within 90 days of a protected activity is retaliatory. So, that's something that many are arguing for at the state and local level. I think we need employees to be able to designate a representative for the Federal Labor Standards investigator to facilitate worker engagement in the enforcement process. So right on the complaint form, right at the moment, that workers need to be able to designate an organization that they're going to work with and that they want to be to have shared with any information. I think that it's really important to think about things like in the Occupational Safety and Health Act, we have a walk-around rule. There's an understanding that when an investigator shows up on a farm and they're not accompanied by a union person or a worker center person or a fair food person or a coalition of Immokalee work, that workers are going to be too intimidated to speak up. And so it's really important to think about organizations that help with filing complaints on behalf of workers, who are present during employee interviews, who participate in workplace inspections and conferences and settlement negotiations. And I think we need a grant program, a significant grant program that's tied to supporting organizations like FLOC and organizations like the Fair Food Program and others, that's tied to the strategic enforcement strategies and partnership with community organizations that we're talking about, a sizable grant program that can support organizations the way that the Susan Harwood program functions on the OSHA side. And I'll just say, I feel like, the news from the Biden administration is really positive about the changes they're making in the H-2A program, right? The proposals to legalize the undocumented population of farm workers, the proposals to have a pathway to citizenship for H-2A workers. These are really, really central to this question because the industry logic is based on exploitation, and it will stay that way if 60% of the workforce is either undocumented or H-2A workers.
Great, thank you. And before we go to Q&A, I will just add a footnote to what David said about funding for Wage and Hour. I published a blog post about a year ago that showed that we spent in 2018 $24 billion just on immigration enforcement, while we only spent $2 billion for all labor standards enforcement agencies combined. So that's just shows where our priorities are and that they're out of whack and that the money is there. It's just a question of priorities. So now I'll go to our first question, and this is one that I think that all of you will have thoughts on. The question comes from Bruce Goldstein at Farm Worker Justice, which is a farm worker advocacy organization in Washington, D.C. He says that the long experience with the H-2A agricultural guest worker program has demonstrated that most of the temporary foreign workers are under such restrictions and financial pressure due to their restricted non-immigrant status and their economic reality that they cannot and will not speak up for themselves or challenge unfair illegal conduct. In addition, they never obtain the right to immigration status and therefore never the right to vote, which means that their employers engage in lobbying and campaign contributions, but the workers never do. So the question is whether the model of guest worker status is appropriate to this nation, which claims to be based on economic and political freedom. So whoever wants to jump in first, just keep in mind that we've only got 10 minutes left and we want to try to get to a few more other questions.
Well, I'll just say I had the pleasure of working with Bruce and thinking about this with him years ago. And he should be on this panel, not me. And so, I think we would all agree that the guest worker program is a terrible thing, and that if we could eliminate guest worker programs, we could and we should. And otherwise, we should reinvent temporary worker programs fundamentally from soup to nuts. And we should eliminate every single piece of the guest worker program that creates all the things that Bruce said about their vulnerability. So in terms of mobility between employers, being able to bring family, having all the rights that anybody else does, farmers having to pay Social Security and unemployment insurance and provide, there's a long list of things that could be done that would make the guest worker program either more palatable or much less financially viable for farmers to prefer over hiring farm workers who are not temporary workers.
If I can answer directly, first of all, I agree with the legalization issue. Always have. but even in the legalization of '86, the Reagan amnesty, I pointed out at that time, and I point out to people now that, look, just because we become legal doesn't necessarily mean the exploitation goes away, because that's an economic inequity issue. So instead of having undocumented and exploited workers, we'll have documented and exploited workers. I was an American citizen. I was raised in those fields. That didn't keep my family from being exploited and our wages stolen. So we have to talk about the economic inequity of the program. And it's that old saying about somebody throws you a lemon, makes some lemonade. That guest worker program is a bad program. It's been documented how bad it is. There's a lot of built-in inequities in that program, starting with the recruitment side in Mexico. But if it's a slave labor program, we can make it a good program and make it a worker justice program. Our job in the labor movement is not to be the politicians decide, have political decisions about these kind of things. We're supposed to organize the unorganized, regardless of their status, whether they be H-2A, whether it be undocumented, whether it be American citizens. We need to organize everybody into the labor movement, because the labor movement gives us self-determination. It gives us a good collective bargaining agreement that has a good grievance mechanism that protects us from retaliation, and we can use it to address the issues that when we get out of bed in the morning. Right now, we are processing worker questions, demands in Mexico on recruiting issues right now in the H-2A program, because we have a collective bargaining agreement. We have the right to do that, and the workers are protected from retaliation for that. So if workers had self-determination and we had a union, we had an institution that represents us, that we work through, we could answer these questions, and we could reform these guest worker programs. And I think they're going to be necessary because we're talking about short-term crops, and you legalize a worker, he's not going to want to stay in short-term crops if he's an American citizen and wants to live in this country. He'll want employment year-round. So those workers will phase out of agriculture into a more stable year-round employment, and they're not going to get that in agriculture for the most part. And so therefore, you're going to have to depend on a temporary program. And those workers have to have a program that is a just program, that is a good program, that they have worker rights and they have freedom of association, and they can represent themselves to protect them from the abuses that are right now prevalent in that guest worker program.
The only counterpoint I would add to what Baltimore said is that there is evidence in the NAS that there are, about workers rotating out. There are still a lot of workers who were legalized under the Reagan amnesty, under IRCA, who are still working in agriculture. They're at an advanced age now, but so I mean I do think some of them might not have better options. So we do need to improve wages and working conditions. David, did you want to weigh in on it?
Well, I think Baltimore and James covered a lot of important territory. I would just add one point, amplifying something Baltimore said. We need to look at the economic drivers that make for bad work in all parts of agriculture. There are institutionalized problems of H-2A that Bruce rightly points out, but the agricultural worker across the board is faced with bad wages, few benefits, a lack of voice, direct exposure to the pandemic, and a whole host of other problems. And that, to me, is where we have to have much more attention. You think about the systemic problems that drive this, and then think about responses that really are attuned to that.
All right, so we only got 5 minutes left, so I'm gonna mention two questions, and the three of you can kind of weigh in however you want on them. The first one is about FLCs. It's sort of directed at Baltimore and David. It's how can policy be changed to force FLCs and growers to be joint employers, and/or can the U.S. Can DOL be forced to ban FLCs from being H-2A employers until some sort of system of accountability is established? I know it's been mentioned that that's a big issue, and David mentioned that that's something we need to tackle. Is there a way in practice that it's done? Can that be a regulation? Do we need a comprehensive new law? What can be done there? And then the other question can go to any of you. is about the bad apple question. Someone asked, are the bad apple employers really bad apples, or are they uninformed apples? Is there anything that shows that ag employers have adequate knowledge of complex wage and hour laws, particularly in certain states with greater numbers of labor laws? So that's this question: Do employers need more education? I know that the Labor Department does regular trainings and presentations. The Office of Foreign Labor Certification does these all the time. So so if any of you want to weigh on that, then I think Phil might want to weigh in on that as well. So take it away, whoever wants to jump in.
Can I just say a couple of things? The first thing, I think that, there are a lot of issues in agriculture, but I think it's important to remember that 30% of the investigations find no violations. One of the things we might want to keep in mind when we look at this is not just what lessons do we learn from the bad, but what lessons can we learn from the good? I mean, there are people who actually do comply. We don't really know much about labor contractors. The last study I can find on farm labor contractors is from the 1990s. And then the average contractor in California had 15 clients. Now, is that still true today? There are some very big labor contractors out there who work only for one company. It might be worth thinking a little bit about what makes some work and what makes some not work. And that might give us a little bit. Both Baltimore and David has mentioned the whole supply chain issue. How do you have accountability up and down this? And this is not just agriculture. This is true in garments. This is true in a whole lot of industries. And what I sort of think is, can you look at what has succeeded in supply chains? The biggest revolution in the fresh produce supply chain has been food safety. And it came about, there was an economic incentive. You sell bad spinach, that means the price of spinach goes down. I can't sell my spinach. What was the response? It doesn't eliminate food safety problems, but it's this idea of continuous monitoring, setting norms, trying to point out anomalies, and when something happens, tracing back as quick as possible to where it goes. Can we learn something from that might help with labor law? And then the final point is this bigger question of agricultural policy. It's been true, whether it's labor or whether it's farming, the message has been get big or get out. So what do we have in agriculture? We have a 90-10 industry. The 10% largest farms account for 90% of farm output. And the 90% smallest farms account for 10%. It is hard for anybody at the small end to deal with complex agricultural farm policies, agricultural labor policies. We have to really think what our goals are, because it will be hard to pass laws that increase complexity, but nonetheless preserve those small, medium-sized family farms. In the interest of time, I'll stop there.
Yeah, so if we could just maybe get 30 seconds to 1 minute from all three of you, Baltimore, David, and Janice, responding to any of these questions and concluding.
Well, I really agree that what just was from Philip's comments, but I really think that if we had the issue of freedom of association, you would have a collective voice to inject yourself to create the creative tensions in a supply chain that is not just here domestically, it's global. And we have to have a voice there in order for farm workers to be able to take their role with their suppliers and the global corporations to create a sustainable model so that we can have a fair chance at life and grow up our children that have a fair chance in life. So I think it has to do with not only the workplace, Philip, that we're concerned about, is why we believe in an institution that's a democratic. The workers elect their own leaders, define the direction of their collective group, whether it's a union or whatever participatory democratic model we can create for them, because we also have to represent ourselves in the public interest, the public debates that impacts our quality of life. So where are the farm worker unions in this country taking their place in the seat of Congress? to have our voice held in public policy, so that we can improve the quality of life, not only in the farms that we work on, but in the communities in which we live, because our children have problems with the local schools and local police departments, all these things that impact other low-income people impact us too. And we need to have a voice there, and we have to have a vehicle for which to speak through. And that's why I believe that farm workers need to have a union, collective bargaining, an institution of their own that represents them not only in the workplace, but in the public policy.
Baltimore, thank you. We are over time, so we just get 30 seconds from Janice and then David, and then we're going to be done.
I'll just say, if I could do one thing with leadership of Wage and Hour, and I would take them to Immokalee, and I would walk them around and show them the Fair Food Standards Council and the Fair Food Program, because I think it's really important to see that there are models that are working. Right, this is a place that was hell on earth, and that has been significantly, dramatically improved. And although it's not a union, there's a very strong community-based organization that's where workers are in major leadership positions, and workers are playing a role. And there is massive worker education, worker rights training. There's requirements on every farm that there's worker rights being taught. There's information being distributed to workers about their rights. There's a 24-hour hotline with a 48-hour turnaround. There's direct employment, time clocks in the fields. I just think it's really important to expand our imaginations about what is possible. And I think they're doing extraordinary work. And that it's worth taking a look at what we can learn, as Philip said, from a variety of programs.
Thank you, Janice. Just last 30 seconds. Any last words, David?
Yeah. So I'll go more micro on your joint employment question, and it's something that the Labor Department could deal with. It's a legal issue, so maybe I'm always in trouble if I'm talking law as an economist. There is an anomaly in the H-2A program in terms of how joint employment is defined, and it is defined in a much more narrow way than it is under MISPA. MISPA uses the suffer and permit language of the Fair Labor Standards Act, which is a very broad definition of joint employment. That should be adopted in the H-2A program. The reason you have these farm labor contractors, in part, playing these games under the H-2A program is a flaw in the definition of what is joint employment. We should adopt this same kind of broad language to allow that kind of joint employment application in the H-2A space that we have under MISPA and FLSA.
Great. Thank you so much to the panelists. Thank you for the kind words about the report. Thank you for thinking about these issues and sharing your thoughts with us. And thank you to the participants. And with that,